everybody's ready, we'll get started. Thank you so much for coming today for our presentation. I'm very excited to have our two speakers here to discuss legal documentation and how to protect you in the hospital against the medical malpractice claim. And it's something I know that we think about often with our nursing documentation. Our first speaker is Lauren Zaletka. She's a partner at Ronan Vizio and G&O Law Firm. Ms. Zaletka has specialized in defense of medical malpractice claims for over 20 years. She has represented physicians, residents, nurses, hospitals, and nursing homes. Lauren has provided legal counsel to the hospital and staff members for many years, and some of you may already know Lauren. And our next speaker is Marissa Casoy. She is a senior counsel in the System Corporate Legal Department. Some of you may also know Marissa. She handles litigation and subpoenas to the system, as well as licensing board investigations and guardianships. Marissa has focused on healthcare law for over 20 years and provides legal assistance on many healthcare and medical staff-related issues. So I want to thank you both so much for being here today, and we'll get our presentation started.
Thank you, Margaret. Thank you so much for joining us this morning. I know it's not always a pleasure to hang out with lawyers, and so we appreciate your coming. And what we're here today to do is hopefully to minimize your future contact with lawyers, because really, there's no better way to spend the morning, right? So we kind of think of it this way. How do you avoid being involved in a lawsuit? And we'll go through some of the ways that you can avoid being sued in the first place, and then we'll talk about what things you can do to make sure that if you are involved in a lawsuit, you're in the best position possible. And we like to think of this as kind of like your annual physical. If you get a regular checkup every year, you're less likely to get sick, right? So if you do the things you need to do for your health, like see your doctor every year, you're less likely to get sick, and it's the same for a lawsuit. So if the lawsuit is an illness, have an annual checkup with your lawyer, and maybe you'll put yourself in a position where you won't be facing that lawsuit. Other things that you do for your health, like annual mammographies, colonoscopies, those are things that you want to make sure that if you do get sick, you're in the strongest position possible to fight that illness. And that's the same thing that we're going to do here today. So we're going to give you some tips and techniques to maybe prevent getting sued or to put yourself in the best position possible to fight that lawsuit. And I am well aware that I just compared the seminar to a colonoscopy, and we're okay with that because it's important. And hopefully, like I said, it'll avoid your contact with us in the future. And P.S., there's no prep involved, and we won't charge a copay. So it's all bonuses. But those are the important things to be mindful of, because in your everyday world, you need to be very focused on clinical care. Obviously, the patient always comes first. But these are some little things that we can tell you that will be kind of rattling around your brain there. So when you're focused on your patient, you're also cognizant of some future things that might be important that aren't immediately recognizable today. So getting regular checkups with your lawyer is a good thing to do. Keeping up to date with your continuing education obviously is a good thing to do. But what we found is the way we communicate with our patients and with other medical providers can be a critical factor in whether or not a lawsuit is filed. And it's actually something that Marissa and I have come to realize over the course of years in practice, that we see a lot of things that you wouldn't expect that cause a patient to kind of flip that switch and decide to file a lawsuit. Bad outcomes happen, complications occur, but something has to happen for that particular patient to decide, I'm going to talk to a lawyer about this, I'm going to sue someone. And it really boils down sometimes to just communication. We've talked to hundreds and hundreds, maybe even thousands between the two of us, patients who have had a complication and decided to file a lawsuit. And invariably, they all have complaints that they're so anxious to tell us about that really have nothing to do with their clinical care. They're just so angry and so caught up on something innocuous like the nurse was writing while I was talking to her and she wasn't paying attention to me. The doctor didn't call me back. The nurse said the doctor would be in and he wasn't. Like things that really had zero impact on their clinical course, had no connection to whatever the medical issue was, but that seemed to be their focus. That seemed to be the impetus for them to go talk to an attorney and decide to file a lawsuit. So that's an easy fix. So that's something that if you're cognizant of just being your best self and talking to patients, making that connection, using their name, making sure they know your name. Invariably, when we have a patient who's filed a lawsuit, they don't know the name and sometimes can't even describe the person, the medical provider that they're angry with, that did something wrong to them. If there's someone that was kind, they know their name, they don't want to sue them, whether or not there's a connection to the injury. So it really is that psychological component where just making that connection can prevent a patient from either filing a lawsuit or including you in a lawsuit. The practice of active listening can be very important because being in a hospital every day is routine for us. It's not scary, it's not intimidating. But to a patient who's in the hospital, that's unusual. They're ill, they're scared. So the world is now revolving around their issue. And you're very busy and giving them the attention, the clinical attention they need, but you need to practice active listening to make sure that they really understand what is happening, to make sure that they feel like their complaints are being heard. Even if it's not the most important thing, even if it doesn't take a lot of your time, but to make sure that you make that eye contact, you have that connection with them, and so that they feel eased by their intimidating surroundings. And it's hard to remember that it's intimidating to them. And I try to do the same thing, and I'm sure Marissa does too, because when you come to our office or have to do a deposition or go to court, that's routine for us. That's intimidating for you. So we try to do that same thing, and honestly, I'm better at it now than I was as a new attorney because I didn't have an appreciation of the view from your seat. And it's the same thing with your patients. Try to get a view from their seat where it's not routine for them. They're really scared and they're intimidated by their surroundings. Practicing good PR is always a good idea. So even if something is not working or you're frustrated with equipment or personnel or staffing or any issues like that, that can be interpreted very differently to a patient. And again, it goes back to the patient kind of feeling like they're the center of the universe. So if they hear something like, oh, that x-ray machine isn't working again, and something happens in their case, they're going to then think, I bet it was that x-ray machine. You know what I mean? So they're going to make that connection that might flip that switch where they go to an attorney simply because of an innocuous comment that has nothing to do with them or their clinical care. Also, again, from their perspective, is what are they understanding? Is there a language barrier? We have language lines and interpreters available, and use them. Even if the person says, oh, I speak English, if you get the sense that they're not understanding what you're saying, because they may have the capacity to understand the language in a less intimidating setting with simple issues happening, and they may not have the ability to do that when they're scared and in pain and complex issues are being discussed. So make sure you have a good understanding of what that patient is absorbing and their ability to understand the medical aspects and what's happening with their care. And that can be not just a language barrier, that could be a cultural issue, that could be an emotional or behavioral health issue. So just make sure, and kind of that's where the active listening comes in, to kind of get a sense of, are they just yesing me, but they really don't understand what's happening, or, you know, am I getting through? And the last thing is being honest and keeping promises, and obviously this is a basic thing, but it comes down to simple things too. I once had a plaintiff in a lawsuit who couldn't wait to tell me how every time they asked for orange juice, the nurse said she'd bring it and it never came. Like that had nothing to do with their care or their issue, but that might have been why they ended up going to see a lawyer. So it's just as simple as don't make a promise you can't keep, and just be open with your patients and try to make that connection, because you never know what innocuous thing might flip that switch for them and send them looking for a lawyer. The same is true for communicating with other healthcare providers. Obviously, you know, we always want all of our interactions to be respectful, even if the other party is not being respectful or is not being helpful. But this is all stuff that may play out either within the sight or the hearing of a patient. And again, if you go from the perspective of they're the sun and everything's revolving around them, they're going to interpret strange body language or a heated discussion as something to do with them. And that can be really significant because it's going to ratchet up their fear, it's going to ratchet up their suspicion, and then if they do have a complication, that they'll have that aha moment, I can't wait to tell the lawyer, you know, the providers weren't agreeing about me. And it could have been a discussion that has to do with lunch. But if the misperception is that there's some sort of issue going on, they're going to immediately assume it has to do with them. And communication with healthcare providers, just like any other work environment, it's easier with some people than with others. But if you focus on being accurate, being efficient, being complete, if somebody's rushing you off the phone, have a standard practice for getting out the significant information you need to communicate in an efficient way. That way, no matter how abrupt or abrasive the other person is, the information gets communicated. And again, always be aware of the patient, what they can hear, what they can see, because it really is something that they have such a different perspective and impression of what's happening around them that you'd be surprised later the stuff we hear and why they even remember that years later, never mind why they think that's significant. So these are some of the tips and techniques that we found actually help prevent a lawsuit or prevent your inclusion in a lawsuit. I actually have two clients in mind when we talk about things like this. One was a brilliant surgeon who had the worst bedside manner ever, and he was sued multiple times with cases that had zero merit, but I'm convinced it's because of his demeanor. And I've also had more than one client where we've met either through root cause analysis or through just a phone call with, oh my gosh, there was a mistake made and a lawsuit's coming, and the lawsuit never came. And I'm convinced it's because of the connection that that particular nurse had with her patient, and another was a physician in an office practice. So it really does make a difference. It really can be the thing that flips that trigger, and it's an easy fix. So that's something to keep in mind when you're caring for your patients every day. But the unfortunate truth is there are this many legitimate lawsuits that could be filed in New Jersey, and there are this many lawyers. So do the math, and we're just a very litigious society, and more we're seeing practitioners get involved in lawsuits in one way or another. So that's a big reason why we're here, because we want to do everything we can so that you don't get involved in a lawsuit and you don't get sued. But unfortunately, even with the best care, lawsuits happen, as they say. We just created a bumper sticker. Lawsuits happen, and so it's important that you know in advance kind of what to expect and what things are likely to occur if that does happen to you. So Marissa's going to take over and bring you back to school with Lawsuits 101.
So we've been hearing some terms today. A plaintiff. And some of you may be thinking, well, what does that mean? A plaintiff is the person bringing the lawsuit. A plaintiff is the person prosecuting the lawsuit. A defendant is the person defending the lawsuit. So you have plaintiff. It starts with a P. I'm going to make this easy for many of you in this room. Patient. Equate that with patient. Or a family member can bring the matter on behalf of the patient if they're deceased, or perhaps if the family member has been appointed as guardian for the patient, or if the patient is a child, so the parent or guardian can bring that lawsuit. That's who's bringing the lawsuit. Defendant, the person again defending the lawsuit. The doctor, the clinician, the person involved in the care and treatment. That can equate with nurses. My understanding is there's the primary people here today are nurses. Is that correct? Okay. Any other clinicians? No? Okay. So if you're involved in the care and treatment of a patient who does decide to bring a lawsuit, you could be involved in a lawsuit as a defendant. You could also be involved in a legal matter by way of as acting as a witness. You could be subpoenaed, okay, which is a formal document. It's essentially a court order subpoenaing you to appear for a deposition. It's a question and answer session under oath. You'd be represented by counsel. You'd answer questions to the best of your ability. You essentially are there to just testify regarding what you recall, what you documented, and if you don't recall certain information, or if you don't have certain information because you weren't involved or you don't know, that's perfectly acceptable. So there are ways to get involved in lawsuits, either being sued yourself or being a witness, okay? And it's not truly being involved in the ballgame, but you could be involved in the ballgame. You could continue not only being a witness at a deposition, but if the case were to go to trial, testify in a court of law. And at times, after the initial complaint has been filed with the court, the attorneys for the plaintiff, the patient, may decide there's additional parties that need to be brought in, okay? So at all times, if you hear about a lawsuit that is involved, it's very important that you don't discuss it amongst yourselves. If you want to discuss a matter that you've heard of that's in litigation, or that you've heard that there's depositions involved, or other people have been called to testify as witnesses, you're best off going to one of the departments in this facility that really can assist you, and that is risk management. We have Margaret Nielsen here today. Her department is willing and able, and the doors are open. If you have any questions, go speak to Margaret about it. You're better off not speaking amongst each other about it. There are counsel, in-house counsel, and outside counsel that are here to assist you, whether or not you have questions of being brought into a lawsuit, whether or not you have questions of whether or not you're going to be called as a witness, subpoena, okay? And if you're involved, we're here to assist. But if you speak amongst yourselves, it can create problems. Why am I saying that? Because if you discuss it with counsel, it's protected by attorney-client privilege. But whatever you discuss amongst yourselves, it's not protected. All bets are off. And so when you are involved in that lawsuit and you are asked under oath, okay, what did you say to your colleague, nurse A or nurse C? You're under oath, you need to tell the truth. You need to talk about what you talked about amongst yourselves. Okay, so you're better off just speaking to counsel. And the way you start that discussion is to reach out to risk management. Any questions about that? Okay. As part of your employment, you are afforded insurance coverage, okay? Lawsuits in a medical malpractice arena are not criminal matters. No one's seeking to put you behind bars, okay? No one's trying to essentially take away your license. It really boils down to it's about money. They're seeking monetary damages. You are afforded insurance coverage as a result of being an employee of the medical center. You may also have your own personal insurance coverage. I believe there's NSO and maybe some other ones out there. So you have insurance coverage, but just keep in mind, I wanted to make sure you all are aware, it's not a criminal matter, it's a civil matter, and monetary damages are being sought. How do you get involved? Essentially, a complaint, okay, someone essentially spelling out what they believe was wrong, okay, how they were damaged, is filed with the court. And then they need to serve it on the individuals they are suing. Here at the hospital, if you're an employee of the hospital, the Department of Risk Management accepts service for you, service of process, okay, of that complaint if you were involved in that lawsuit as a defendant. On the same token, risk management accepts subpoenas if you are being sought after as a witness in a matter, in a legal matter. Same with respect to, there's some criminal matters where you may be sought after as a witness. We see it a lot in blood draws involving motor vehicle accidents or issues. The nurses are asked to testify regarding a blood draw or perhaps something that the driver or drivers said when they came into the facility to be treated. Risk management accepts those legal documents for you, and then it is funneled through in-house counsel, and sometimes we assist you or we engage people like Lauren, and she has a great team as well, to assist you, okay? So you have essentially a team, beginning with risk management, that assists you with these legal matters, because we know what's important on your daily basis is treating and caring for those patients, doing what you've been trained to do, not to deal with these legal matters. For the legal matters, we are here to assist you. Do not, if you for somehow receive a legal document, a complaint, a subpoena, if someone approaches you and wants you to testify, don't go at it on your own volition. Know that we are all here to help you. Seek out assistance that need and are here for. So just please make sure you don't go at it on your own volition. Reach out and seek the assistance that is there for you. Now, what are the types of claims that are usually alleged in these complaints? Failing to assess the patient, failing to evaluate the patient, find out what the needs are, what the issues are, essentially doing the, let's say, doing a head-to-toe evaluation, looking to see whether or not, we see this very often in wound care cases, not assessing the full body, looking, underneath the feet, looking at the heels, looking at the sacral area, failing to fully assess what there is to be seen when you are involved in the patient's care and treatment. Failing to treat the patient, failing to give certain medication that was ordered, failing to work within the management, the care team, get the patient in with, let's say, if the patient needs some lab or some test, not getting the patient there, okay, or failing to draw the blood for the lab that was necessary. Failing to monitor the patient. If there's a change in status of the patient, okay, you need to be aware of it. Not all patients are on telemetry, and therefore not all patients, the bells and whistles will go off when there is a change in vital signs. So failing to monitor the patient for changes in vital signs or changes in skin integrity or changes with respect to, let's say, their pain level. That may be a sign of something going on. Failing to communicate with your fellow clinicians. We see this a lot where, let's say, the lab or pathology or a consultant is calling the unit to relay very important information to the treating physician. And they speak to people like yourselves, the nurse, and say, hey, let the doctor know there was some irregular negative value with respect to labs, or there was a finding with respect to the radiological study. making sure that you let the physician know of that. And we're gonna get into it further, making sure that when you do let the doctor know of that issue with respect to the lab or the radiological finding, that you document it as well. The documentation needs to demonstrate that there was communication amongst the clinicians, that the information was given to each clinician so that the patient could be cared for. Essentially, it's always advocating for your patient. Informed consent. Many of you are asked to witness consent forms, right? Okay? It is not your obligation, it is not your duty to get the consent. It is the doctor's. Okay? You're there only to witness it. So essentially, you may be hearing the discussion regarding, let's say, the risks and complications associated with perhaps a surgery that the patient's about to consent for. The risks and complications associated with some type of medication that the patient is about to get. You're a witness, so therefore, there are some matters where you may not be involved as a defendant, but you may be called in as a witness because you witnessed the consent provided. And whether or not there was enough information given to the patient so that that patient can make an informed decision to consent or withhold consent to that procedure or that medication or that medical care and treatment. So those are the types, some of the types of allegations, the types of lawsuits that we see. Any questions on that?
Sure. You just said, okay, you would still be called in to see if the doctor gave proper information to the patient was able to grasp that information, but we're just witnessing the consent. Is that what I got? No.
You're just witnessing the consent, but if you're there during the discussion, you may be called in to say, hey, Nurse A, what did you hear? What was the discussion amongst the patient and the doctor? Okay?
It's not really
So
wrong.
it's not your opinion whether or not they received proper informed consent. It's you're a witness to the discussion between the doctor and the patient. Does that make sense? Okay. So what's the best defense for any claim lawsuit? And the key is documentation. Documentation in a lawsuit is used to identify the clinicians involved, find out, okay, who were the players, who was involved in the care and treatment of the patient, find out, okay, what was done for the patient, who did what, find out the timeline, okay, of when the patient received certain care and treatment, what was done, who did it, and it essentially serves as evidence to demonstrate what was done and what was not done. And what I mean by that, and I think a lot of you have heard this before, in these matters, if it's not documented, it's going to be assumed it was not done. It'll be held against you. It hurts the defense. Your word is just going to be your word. That you'll be having this documentation, this medical record up there, and they'll blow it up, they'll put it up on a screen like this, demonstrating to a jury, okay, and it's the people that are deciding these medical malpractice matters are not essentially a jury of your peers. It would be really, really nice for us to get a jury filled with medical providers, people like yourselves. It's all different people, it's lay people out there. And they will be hearing you say, well, I did it, but I just didn't document it. And one of the things that we cringe over as attorneys, I was too busy, or I had to rush home, or I forgot to do it. And then you have the documentation where the, especially now in Cerna, where there's even questions or, essentially sections that ask you for specific information, and it's left blank, and you've now signed off on your charting, and now you're faced with this lawsuit, and you have this blank, or you failed to document it. So essentially, if you're gonna learn anything from today, it's just make sure you document, and yes, take that extra time during your shift to complete your documentation and make sure it is fully complete. I'm gonna pass the baton over to Laura.
So let's talk a little bit more about the medical record. So for you guys, it's a clinical tool. It's something used to communicate, but it's also a legal document. It's a really important legal document. It's treated in the courtroom differently than just about any other document that we produce. And I like to think of it as a book. So it's a book that should tell the story of what happened to the patient when they came in and then when they left. And like any good book, it shouldn't be confusing. There shouldn't be gaps or omissions. It shouldn't take really crazy twists and turns that you can't understand. So it really should tell that story. And I probably think of it that way because lawyers are storytellers, right? That's what we do for a living. So we get in front of a jury and we're going to tell them a story. And so our story, we want to talk about the excellent care that you all give every day. That's what our story is going to be about, the excellent care. We don't want to spend time having to convince someone what actually happened. We want that to be very clear, and so that we can just get to look at this great care that was given to this patient. Now, patients' attorneys, they tend to work backwards. So they have a client come into their office with some significant medical complication or injury, and they think dollars, right? So they start with the injury, the complication, and if it's worth enough money, well then by gosh, they're gonna move backwards and try to figure out how to write a story that gets them the cash. So if they then get the medical record and there are some gaps or omissions or something's left up to question, well, the story they're going to write is one that ends in a payout. So that's where the book, that medical chart, becomes the deal breaker. Because when you're in the courtroom, the patient's telling one story, we have a different story. There might be other doctors or practitioners that have even a third story. And who's the jury going to believe? The deal breaker is going to be that novel that was written long ago when the patient was here. The information that was contemporaneously written down at the time before anybody realized strategically what was going to help them in the courtroom. So that's going to be the deal breaker. And I promise you, the hospital chart, if you have to come see Marissa or I, you'll either want to hug it or you'll think, oh my gosh, it's the worst thing ever. And most clinicians, if they have to go through a legal process, think of documentation differently after going through the process. So that's why we want to get ahead of that and get you this information ahead of time so that you have it in your mind. And again, the focus is and always will be the patient and the clinical care that you need to give. But these are some things that we've seen in our experience that clinicians had to struggle with. So we want to make sure that you're aware of it so that hopefully it helps you either avoid a lawsuit or put you in the best position possible to defend it if you're involved. So the first thing you have to realize is that we're not going to call you tomorrow or next week about a patient you saw today. There's going to be a long passage of time. So you're not going to be sitting in Margaret's office or my office or with Marissa and we're looking over a patient you saw a few weeks ago that you have a memory of. There's a statute of limitations in New Jersey, and does anybody know what the statute of limitations means? Statute of limitations is how long you have to file a lawsuit, okay? So from the time that you're injured until the time you file the lawsuit, New Jersey statute says it's X amount of time. Does anybody know what it is in New Jersey?
7 years.
No, it's 2. 2 years. But what if you're not 18? So you have 2 years after you turn 18. And 7 years, there are statute of limitations for contracts and other things, but for medical malpractice claims, for wrongful death claims, it's 2 years from the date of injury, it's 18 plus 2 if you're a minor, and has anybody ever heard the term discovery rule? That's a rule in New Jersey that essentially says to patients who are injured, we'll let you wait till you figure it out and then give you 2 years. So that's almost an indefinite statute of limitations. So we're not going to call you next month or next year, maybe 5 years, maybe 18 years from now. We'll call you, we'll show you your documentation and say, do you remember this patient? And you're not going to remember. Of course you're not going to remember. So that's how critical whatever you put down tomorrow is going to be, that we might call you 18 years from now and we'll have to figure out what happened. And you'll have to figure out what happened in a way that you're confident and can tell a jury, oh, absolutely, here's what I did for this patient. And I know with 100% confidence, here's what I did for this patient. The other thing that's surprising to many people is the condition of the chart when we actually have this meeting. Because it doesn't look like it does in the computer. It might have been so long ago, it's a handwritten chart that's been scanned and copied, and if it was even close to not legible when you wrote it, it's going to be very difficult to figure out when we look at it in the future. And even the electronic charts now, well, we don't have to worry about handwriting for the most part. The computer prints it out in a way that's not as familiar to you as how you input it. So it's not always organized or located in the same fashion, so it gets a little bit confusing to try to find. So that means that whatever you put in there needs to be so clearly recognizable to you that you're able to use that to confidently say, I don't remember this patient, but I know I did X, Y, Z. And that's another common thing that nurses don't realize and physicians don't realize, that when you do come and meet with us, even a decade after your care and treatment, it's not unusual for you not to remember the patient. You see hundreds and thousands of patients throughout your career. So it's not unusual that you don't remember the patient, but you're allowed to testify to your common practice, to your standard practice. You're allowed to testify to that. And that's one of the keys that we're going to use for successful documentation. Because it's not about more. More isn't always better. You need to be efficient. You need to be consistent. So in the same way that you do head-to-toe assessments or neurochecks, in the same way, in the same order, almost unconsciously, you do it that way so you don't miss anything. You do it that way so that you know, if I did a head-to-toe, I know I did X, Y, Z. Your charting should be exactly the same. You should have a custom and practice, make sure you're consistent, so that even if you use fewer words, you know, if I wrote down that sentence or those few words, that means I did X, Y, Z. So that way, 10 years from now, when you're sitting in my office and testifying and saying, I don't remember this patient, but I know that a patient with these complaints where I wrote that sentence means I did X, Y, Z, 100% confident. That's a very fair thing for you to testify to. That's something that jurors understand. And honestly, jurors, I think they're predisposed to believe nurses, to be honest with you. I think they relate more to nurses than they do to physicians. I think they see you as advocates for patients, and they put themselves quickly into the patient's position. And I think if you have good documentation like that, even if it doesn't spell out everything that you did, and you explain, well, my focus is the clinical care, and when I write X, Y, Z down, that means here's what I do with my patient. They're going to believe that. That's common sense to them. They're going to believe that. They're going to trust that. And you're going to have that documentation to prove it. So that's really important as far as factual descriptions and information that you put in there. More isn't always better, because the focus does need to be on the clinician. We don't want you to spend more time on your charting than you do caring for the patient, but you need to capture exactly what you did in a way that allows you to remember it years down the line when you no longer remember the patient. Timing and dating of entries is really important. We thought this would get better with electronic medical records. Sometimes it gets more confusing. It's really important if you have a note and the computer's documenting what time the note went in, you need to make sure that if the action took place at a different time, you actually put that in. We call it an internal time, but it's essentially to avoid confusion. So if you gave meds at 4 o'clock and then spent the next 30 minutes doing XYZ with the patient and you chart all of that at 5 o'clock, it may be very important that the meds you gave was at 4 and not 5. So that needs to be reflected, because again, you're not going to remember. We had a case where a call went out to the doctor for an emergency, and the doctor arrived and did ultrasounds and all sorts of tests, and at the end of all of this emergent activity, the nurse charted and started with 5 o'clock, doctor arrived, ultrasound performed, orders issued, da 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 da. There was a lawsuit over how long it took the doctor to arrive. The nurse very clearly remembers, no, the doctor got there right away, that's why I didn't call again, and he did all of that stuff and then I wrote it at 5 o'clock. But because her note started 5 o'clock, doctor arrived, they hung their hat on, hey, you called him at 4, he didn't get there till 5, and then all the stuff took place. So it really was just a matter of semantics almost, that the charting needed that internal time, so the documentation's going in at X, but here's what happened earlier, and in what order. And believe me, the order matters. If you just put everything in a note and not necessarily in the chronological order that it happened, or designating what time it happened, that can be critically important later. We had a case where there was a code in the OR, and the anesthesiologist wrote, the cardiac monitor sounded, the patient turned blue. The operating physician wrote, I noticed the patient was blue, cardiac monitor sounded. We then had an entire lawsuit over whether there was an airway issue that caused respiratory distress and a cardiac arrest, or whether there was a cardiac arrest that caused the hypoxic injury and the respiratory distress. It became an entire chicken and egg discussion, and the thing that the plaintiff's attorneys were hanging their hats on is that the operating surgeon said, I saw his face was blue, cardiac monitor sounded. And he was taking that as one came first and then the other. And that's not factually what happened. At the time, there was no significance to how that note was written. There was no clinical importance to the patient. But it became the focal point of the lawsuit. So that's why these internal times, chronology can be important, and be aware that the computer is tagging what you're doing. So you can't be inconsistent with what the computer is going to say the time was that something happened. Plaintiff's attorneys are getting very tech savvy, much to my chagrin. I still have a BlackBerry. But they are very, very tech savvy, and they're asking now for audit trails and for internal metadata, all these terms, I don't even know what they are. But so the computer is tracking things so that it can tell what you did and when. So you need to make sure that whatever you're putting in is consistent with, you can't, if you're, not only is it tracking what time you're putting it in, but it may track if you change it or how you change it, things like that. So just be very aware of that. And also the logging in and out. Be very careful with that, because you don't want to accidentally chart for someone else or have someone chart for you, because then that would be confusion if we don't figure it out for 10 years, and then it looks like you were there when you were off that day. So those are the kind of things, just with the computer, the things that we thought it would be easier for is actually giving us a few more things to be cognizant of. Really important stuff. And the dreaded cut and paste. I mean, with the ease of technology comes the ease of repeating mistakes, unfortunately. So be very careful with things that are cut and pasted. We've had cases where we're talking about the patient's left leg the whole time he's in the hospital, and we amputated the right one. Factually, we treated the patient correctly, we just recorded it wrong. And is it explainable? Yes. But think of being in a room full of lawyers trying to explain how you're such a conscientious medical provider and you pay attention to detail and you're careful with your clinical service, yet you have an incorrect note that was just repeated from somebody else. So that's gonna give the counter impression of how conscientious you are. And even just like misspellings and things like that. Does it have clinical significance to the patient? No. But when it's blown up this big, and you're then defending your care, you don't want a misspelling up there. It just adds to the bad impression, and then we have to fight to overcome that, as opposed to, like I said at the beginning, just starting off with good care. This is what happened, we know this is what happened, we can read that this was happened, and let's show the jury that it was good care. Some of the other things that go beyond just your direct care of the patient that can be significant, and one of them is continuity of the record. Again, if you go back to it being a book or telling a story, if there's something very different that's happening from one chapter to the next, there should be an explanation for that. So be conscious of what was charted before you, what's charted after you, because your charting needs to fit within and make sense. So if there's charting all night about somebody's heart rate, and then no mention is made of it the next day, well, did the issue resolve? Was it just, because if there's a gap and there's a question, we know how the patient's attorney is going to write that chapter for us. They're going to say it was ignored or it was forgotten. So be mindful of the continuity of the record and how big picture your documentation looks within what's being written before you and what's being written after you, particularly with consults being called or other physicians coming in, so that we want it to look like everybody is aware of what's happening with the patient and people aren't off on their own, or maybe even talking about a different patient. Sometimes it can get so inconsistent, and we'll show you an example of that later, that it almost looks like it's not the same patient. That can make it very difficult to defend the care that's given if it's confusing like that. Gaps and omissions, these tend to occur either when everything's fine or when all hell's breaking loose. So those are the easiest times or the most frequent times we see a problem with the documentation. And when everything's fine, that's the time when you also need to be mindful of checking every box and just making sure you're complete. I had a case several years ago where a patient came into not this hospital and had a gastric issue. It was a very short admission, everything went well, and he was discharged without a problem. There were daily assessments to be done with little check boxes, and one of them was the psychosocial assessment, and the nurse just forgot to check the box. She's a friendly nurse. I know she talked to this patient. I know if there was any concern whatsoever about his behavioral health or his mental state, she would have done something about it. She would have checked it. There's no way she didn't do this assessment and that it was normal, but she didn't check the box. And he committed suicide a few weeks after the admission. It had nothing to do with the care and treatment given. It had nothing to do with his gastric issue, which had resolved. But because she didn't check the box, they created this whole story about how there must have been signs, and maybe there was something she could have caught, and maybe she could. It was awful. All over a checked box. Now the opposite of that is I have a case, I had a case with, actually it was this facility, it was a long time ago, but it was a post-operative complication, and they were trying to claim that something happened in the OR that caused the patient to be paralyzed. What the defense realized was that something did happen to the patient after she got to her room when she was doing something she shouldn't have done, and hardware moved, and she became paralyzed. So the issue was, did it happen in the OR or did it happen later? And the only documentation in between that time was a checked box from a PACU nurse that looked like not much of anything, just a checked box, but she knew, I checked that box after they moved their legs up and down, after they press against my hand, I took their will, I checked their strength. One checked box won that entire case. Because she had no dog in the fight. She was not a defendant in the lawsuit. She was just explaining to the jury, this is my documentation, this is what I do every day, and I don't check that box until I know that patient can move their legs. And that won the case. So good or bad, when everything seems to be going fine, make sure all boxes are checked. Make sure your documentation is complete, because it's usually the surprising case that ends up coming back to haunt you, so to speak. And again, when things are crazy, when something catastrophic has happened, that is also a very, very difficult time to get documentation down. But just like in a code situation where they have somebody who's scribing, try, if the personnel is available, to have somebody be taking down notes, be taking down comments. If there's an extra body available, there's always people willing to help when there's a problem. Try to work together to make sure that somebody's keeping track. Obviously, the paramount concern is the patient and taking care of the patient. But be mindful, even while bad things are happening, that this needs to be recorded accurately. This needs to be somehow contained in the hospital chart so that we know what exactly happened, what efforts we made to help this patient. So those are the two times that we see where it can be difficult to get down and capture the good care that we gave, so we need to be even more mindful of that and make sure that that can happen. We have hospital policies on documentation. We need to follow them. If we don't follow our own policies, it's very difficult to convince a jury we didn't do something wrong, because we did. We didn't follow our policies. So when you're in a courtroom and there's a malpractice allegation, what the patient has to prove is that we deviated from accepted standards of care. So the medical community sets a minimum standard of care. This is what the minimum good practice is. And they have to prove that we deviated from that we gave less than the good care that we're obligated to give. If we have a policy, we're setting that minimum. We're setting our standard of care. So if we violate our own policy, it can be near impossible to prevail in court. So be very mindful of hospital policies, practices that we need to do. If there is something unusual happening, if we have an AMA patient, if you have a behavioral health issue, it's particularly things that are not the norm. Be more mindful of charting. Don't be afraid to use quotes. If a patient is not acting the way a normal patient does, or if some unusual things are happening, quote that patient in the chart. That's real. That's believable. And that's something that's going to be helpful if there's an action years later where you remember there was an incident, but you don't really remember the details. So that can be very helpful to you. Late entries and corrections, again, these are things that we have policies on. It's understandable you might not capture something and you remember it later. Nobody's perfect, but we have ways to fix it in the moment or contemporaneously. If you have any questions about it, talk to a supervisor, call Margaret. It's much easier for us to fix documentation when everything is happening, or even days or weeks later, than try to deal with it 10 years down the road when we're wondering, why didn't I put that in there? So there are ways to do it and to fix things when it's happening. Get help if you have any questions on it, but don't leave it and just hope it never comes back. Because believe me, that's the one that will come back, and then we'll have difficulty even remembering what happened, never mind how to correct the issue. And lastly, don't be afraid to chart. I cannot, if I had a nickel for every time somebody told me, well, it wasn't my patient, I didn't chart, it doesn't help. The last thing you want to do is be in front of a jury and say, well, that wasn't my patient. They don't want to hear that. It's everybody's patient. We're all here to help. And if you help, own it. Because you know what? We'll find you. We'll know you helped. So we'll find you 10 years from now, and then you're going to say, I don't remember. And I didn't chart because it wasn't my patient. It's going to look bad. And you certainly don't want somebody else charting for you because they may get it wrong. So if you help, if you participate in the care of a patient, put your documentation in there. Don't think that by not having my name in the chart, that's going to save me from X, Y, Z. The opposite will happen. You'll be involved in X, Y, Z with nothing that you can rely on to show what good care you gave. So here are some things that we've pulled out of charts over the years. Pretty funny. Patient showering with nurses, not exactly G-rated. Large BM up walking the hall, that's one of my favorites. Patient hot in bed, that's always what kind of place we're running through. So these are funny, and you know, when you find these on Facebook too, and you see these around, but just like the typo, just like the misspelling, you know, this has no clinical significance. This didn't hurt the patient. But if one of these patients had a bad outcome, and now you're sitting in a lawyer's office or God forbid a courtroom with this thing blown up over your head, and you're trying to give the impression that you're this, you know, attention to detail, caring, conscious practitioner, that's a problem. So it's funny, but it's embarrassing. And some things that aren't so funny are things like that when you're involved in a lawsuit. But here's some actual documentation of a case that was 100% defensible. I had a wound expert who was convinced that this patient who was found on the floor at home had a deep tissue injury on her sacrum and buttocks, and it was going to progress to a stage 4 pressure ulcer no matter what anybody did. But take a look at our documentation to see whether or not we could prove that. So initially we have the emergency room doctor who understandably was focused on her very critical condition, and unfortunately he says there aren't any pressure sores, no. So it looks like she came in with completely intact skin, which is not the case, because the ER nurse did note a very large bruise and a contusion, and it was all over her buttocks and sacrum. But then she also has a pressure ulcer, which she explained to me was, oh, that must have popped up and I didn't make it go away because I was calling it a bruise and not a pressure ulcer. But in retrospect, it looks like, did the patient also have a pressure ulcer and a bruise, or was this one in the same? Not very clear. She couldn't remember. The patient then goes to the floor, and this nurse describes it differently because she's considering what was on the right buttock, stage 2, and she measures it. But she doesn't mention the bruise because she didn't consider that a pressure ulcer. That was just a bruise, and she didn't notice. But if she had realized how the ER nurse had described it, she could have done better with her description to say, oh yes, I do see the bruise that was noted in the ER, but here's what I think is going on with the right buttock. And that would be perfectly consistent with the evolution of a deep tissue injury. But because she wasn't aware of how this patient's backside was described earlier, her description seems very inconsistent. And then you have the nurse that came on at 3 o'clock, and again, she chooses to describe it differently as well, separating what's going on in the buttocks and the sacrum and measuring, we're not sure because this says right buttocks and sacrum and this says sacrum. So now we're not sure how many wounds are involved, where the bruises are, or whether this is something that happened later or is an evolving process. And then finally, we have the following morning, the large bruise on right buttock and sacrum, which is actually consistent with what she came in with, except that we now have stage 2 open on both. So when left with this documentation, even though we know the absolute truth is this patient came in with a deep tissue injury that was progressing as expected to stage 2 and ultimately stage 4 ulcers, the plaintiff was arguing she came in with no skin breakdowns and that we caused stage 2 ulcers that progressed to stage 4. We had to resolve this case with a settlement because the documentation didn't support what factually happened to the patient. You can see glimpses of it, and you can see some connections, but if the nurses were mindful or looked at how this patient's buttocks were described in prior notes, they could have molded their notation to be more consistent to show a consistent picture. It would have been difficult to show this was the same patient. Never mind that it was evolving how it was expected of a deep tissue injury. So this is a good example of not only accurate documentation so that you can go later. For example, the 3 p.m. nurse, she couldn't explain what exactly was on the buttocks and sacrum, where was this measured versus this appearance on the sacrum with a different measurement. There were no photographs taken. She couldn't picture that 5 years later. And we certainly couldn't use these conjunction to show what medically he knew happened. So these are good examples of attention to detail, making sure what you're writing down is clear so that later when you have no memory of the patient, you can remember and know what happened, but also being aware of other documentation so that we have some continuity.